So, what is creditors voluntary liquidation? Well, this is, at the moment, perhaps the most common way for a director to close down an insolvent company, a company that cannot pay its debts when they fall due, or a company whose assets are exceeded by its liabilities. And the way the process works is that the director is able to initiate the insolvency procedure to wind the company up. It's known as creditors voluntary liquidation because it is a voluntary procedure. In other words, it doesn't take place through the courts. The director or the directors combined pass a board resolution to put the company into the route of liquidation. And the way you do that is you convene, in accordance with the articles, which is the constitution of the company, you convene at what's known as the members' meeting. The members for most companies will be the shareholders. And if you've got more than one shareholder, for the vast majority of companies, you will need, if you're going to convene a members' meeting, you will need at least two of the members to vote, and you will need to pass what's known as a special resolution. And if you're calling a meeting as opposed to doing a written resolution, which I'll come on to, then you will convene the meeting, and those people who vote at the meeting determine whether or not the special resolution is passed. The special resolution requires 75% or more of the votes cast to be in favour of the resolution. So it's determined by who attends the meeting. So if very few people attend, depending upon their voting rights in respect of the company, that will determine whether the resolution is passed or not. Obviously, you might have members turning up who don't want the company to be wound up for whatever reason, and that can have implications. But the basic principle is those with voting rights can pass a special resolution provided 75% or more are in favour. Now, the alternative to convening a members' meeting is what's known as a written resolution. You need a longer notice period. It needs to be circulated amongst all the members, as indeed if you're convening a members' meeting. But in order to pass a written resolution, it actually will require 75% or more of the shareholders or the members, depending on what kind of structure of company you've got. It will require 75% or more of the members to vote in favour of the winding up written resolution. You cannot deal with it as you could with a meeting based on simply on who attends. But the advantage potentially of a written resolution is you don't have this problem that a members' meeting might have of simply that you need at least two people. If you've got multiple members of a company, you can pass a members' resolution with simply one person when you've got multiple members in the company. Anyway, you've done the board resolution, you've then passed your special resolution, and the company is in liquidation. However, this is an insolvent company, and insolvent companies are run in the interests of creditors. They are not run in the interests of shareholders or the members. The members start the process. The creditors ultimately determine the appointment of the liquidator. So if the members have allocated a particular individual to be the liquidator, who has to be a licensed insolvency practitioner, all well and good. However, the creditors determine the appointment of the liquidator, and there are various means through which the creditors will do that. At the point when the members' meeting or resolution is passed, typically around that time there needs to be a creditors' meeting either literally straight afterwards or within a short period of time. And the creditors, based on the size of their vote, which is determined on the size of their debt, and that it's also determined on what the status of their debt is, because there's various different categories of secured creditor. those who vote in a liquidation will be unsecured creditors where it's down to the appointment of the liquidator. Those creditors will ultimately have the final say in terms of who is appointed as the liquidator. Before the creditors take that decision, they have to be supplied by the company with a statement of affairs, which is a list of assets and liabilities, and a list of all the creditors with names, addresses, and amounts owed, shareholders, names, addresses, level of shareholding. They will also need to be required to be provided with a financial information report that sets out financial history of the company, reasons the company is going into liquidation, and provides explanations and disclosures about the company's last 12 months trading period typically, and the figures in the statement of affairs to give them information that they need to understand why the company's gone into liquidation, what's going to happen next, and ultimately they will perhaps use that to consider the appointment of the liquidator that they're choosing. In many instances with creditors voluntary liquidation, the company or the director's nomination for the appointment of liquidator will be carried through by the creditors, and it will simply be a ratification exercise. But make no mistake about it, the creditors ultimately determine who the liquidator is appointed. Once the liquidator is appointed, he or she will then proceed to wind up the company's affairs in an orderly fashion, realise the assets, and after the costs of liquidation, if there's any surplus funds left available, distribute to the creditor in accordance with the statutory order of payment in insolvency proceedings. Questions, queries, concerned, give us a shout. We know insolvency inside out.